Hello, and welcome to the New Jersey Department of Labor and Workforce Development's webinar, Compliance with New Jersey's Wage and Benefit Laws, What Business Owners Need to Know. My name is Nicole Jacoby, and I am the Community Outreach and Resource Planning Specialist for the Wage and Hour Division here at the New Jersey Department of Labor. And today I'll be taking you through this presentation about various important topics that business owners need to know in order to comply with New Jersey's wage and hour laws. Before we begin, we'll go through a quick disclaimer. This presentation is intended as general information only, and it does not carry the force of legal opinion. Please note that the law and regulations can change quickly. The New Jersey statutes and the New Jersey Administrative Code should be consulted for the most accurate and up-to-date legal information. The New Jersey Department of Labor helps all workers. We enforce laws to protect all workers, regardless of their legal status. We will never ask for immigration information, and we do not share information with immigration unless legally required to do so. An employer cannot withhold payment because an employee does not have a valid Social Security number or because an employee has not completed a W-4 or an I-9 form. Employers must not retaliate against their workers for exercising their rights or inquiring about their work rights. The New Jersey Department of Labor Wage and Hour Division. In this presentation today, we will discuss the following requirements for employers, which include earned sick leave, minimum wage, record keeping, methods of wage payment, overtime, child labor, misclassification, workers' compensation, and anti-retaliation. The first law we'll talk about today is earned sick leave. Employers of all sizes must provide employees with up to 40 hours of paid earned sick leave per year, so they can care for themselves or a loved one or for other reasons prescribed by law. If you have an existing sick leave policy, it must meet or exceed the requirements of the law. Employees accrue 1 hour of earned sick leave for every 30 hours worked, up to a maximum of 40 hours of leave per benefit year. For example, if an employee works 40 hours per week, then they will earn 5.33 hours of earned sick leave in 4 weeks. Employers can also choose to provide their employees with 40 hours of earned sick leave up front. And if an employer already has an existing sick leave policy for its employees, then it must meet or exceed the requirements of this law. Who is covered by earned sick leave? Earned sick leave applies to nearly all employees, including full-time, part-time, and temporary employees. It applies regardless of the number of employees that a business has or whether an employee is paid by cash, piece rate, or salary. It's also regardless of an employee's citizenship status, and per diem and seasonal employees are covered as well as supervisors and managers. Another important part of establishing an earned sick leave policy is establishing a benefit year. Benefit year means the period of 12 consecutive months established by an employer in which an employee accrues and uses earned sick leave. Employers must notify each employee of the benefit year in writing. And to change the benefit year, you must provide notice in writing to the New Jersey Department of Labor Commissioner at least 30 calendar days prior to the proposed change. When can an employee use earned sick time? They could use it to care for themselves or family members, for physical and mental health or injuries or wellness care, to get the COVID-19 vaccine or recover from side effects, to cope with domestic or sexual violence, to attend school-related meetings, functions, or other events for a child, public health emergencies that close work or the school or place of care of the child. And the fifth bullet point here about school-related meetings, functions, or other events for a child is very broad. So this could cover many different types of events that are taking place at school where the attendance of a parent or legal guardian is requested by a staff member at that school. Earned sick leave. What is the definition of family? Family can include a child, whether it's biological, adopted, or foster child, stepchild, legal ward, child of a domestic partner or civil union partner. Could be a grandchild, sibling, spouse, domestic partner or civil union partner, parent or grandparent, spouse, domestic partner or civil union partner of an employee's parent or grandparent, sibling of an employee's spouse, domestic partner, or civil union partner, any individual that's related by blood to the employee, and any individual whose close association is the equivalent of family. So the definition of family is very broad under the earned sick leave law in New Jersey. Using earned sick leave. An employer may choose the increments in which its employees use earned sick leave, provided that the largest amount of earned sick leave that an employee may be required to use for each shift is the number of hours that the employee was scheduled to work during that shift. Earned sick leave requirements. Employers must keep and maintain records for 5 years documenting compliance with earned sick leave, including hours worked, earned sick leave accrued, advanced, used, paid out, and carried over, and these records must be made available to NJDOL if requested. Employers must also give each employee written notice of their right to earn sick leave, and this notice should include how employees will accrue and use sick leave, and the right to file a complaint and be free from retaliation. A special note here is that the earned sick leave law states that records documenting compliance with earned sick leave must be kept for 5 years. However, other laws related to wage payment and record keeping may overlap with this. For example, there are other wage and hour laws that require employers to make these records available to wage and hour investigators during an audit for the prior 6 years. So it's just important to note that the earned sick leave requirement is specific to earned sick leave records, and that's for 5 years, but this may overlap with other wage and hour laws that require employers to keep records for 6 years. And there are a few exemptions from earned sick leave. This would include individuals that are employed in the construction industry under a union contract, per diem healthcare employees, public employees who are provided with sick leave at full pay under any other New Jersey law or rule, and independent contractors who do not meet the definition of an employee under New Jersey law. And we'll talk about independent contractors in a few more slides when we discuss misclassification. Few more earned sick leave requirements. If an employee has a need for earned sick leave, an employer may require documentation only when the employee has used 3 or more consecutive days, it is a high volume period for the business, or there is a special event. Employers cannot require documentation for just 1 or 2 days of absence. Employee health information and data in the employer's possession must be held confidential. An employer cannot discipline an employee who uses earned sick leave for a permitted reason. An employer is not allowed to require an employee to find coverage when using earned sick leave or make up the hours. An employer may require 7 days advance notice when an employee has planned to use sick leave. This could be an example of a doctor's appointment for wellness care. If an employee's need for earned sick leave cannot be planned, an employer may require the employee to give notice as soon as it is practical, and this would be an example of waking up with a fever unexpectedly. Employers cannot retaliate against employees for requesting or using earned sick leave, and you can learn more at our website, mysickdays.nj.gov. How are employees paid for sick days? Employees must be paid at the same rate they normally earn, not including overtime, and at least the minimum wage. Different calculations exist for the following types of employees: tipped workers, multiple rates of pay, piecework, and commission. Employers are required to pay employees in the same pay period, and the pay must come with a regular paycheck or another method that can be deposited or cashed easily. To calculate the rate of earned sick leave pay for an employee whose pay fluctuates, has 2 or more jobs, is paid by piecework, or whose pay includes gratuities, food, or lodging, you would add together the total earnings, exclusive of overtime pay, for the 7 most recent workdays and divide that by the total hours of work during that 7-day period. For base plus commission or commission only, the earned sick leave pay rate is the hourly base wage or the state minimum wage, whichever is greater. Unused earned sick leave. Unused leave time at the end of the benefit year is either carried over or bought back by the employer. Up to 40 hours can be carried over per benefit year. Employees are permitted to have more than 40 hours of earned sick leave in their leave bank. However, an employer is permitted to limit them to 40 hours of usage or carryover per year. And this is an example of the required earned sick leave poster that all employers are required to post at their worksite where employees are able to view it. And you can download and print out free copies of this poster and all of the other required posters in the employer poster packet on the New Jersey Department of Labor's website, which is listed here. And we also have posters in several other languages as well. New Jersey's minimum wage. Employers must pay New Jersey's minimum wage or any higher rate of pay that's agreed upon at the time of hiring. Effective on January 1st, 2025, the New Jersey minimum wage for most employers is $15.49 per hour. The minimum wage may continue to increase each year on January 1st based on a measure of inflation. And as you can see on this chart here, we're going to look at the bottom row for January 1st, 2025. These are the current minimum wage rates in New Jersey. So you can see there's a few different categories for the minimum wage. So for most employers, the current minimum wage rate is $15.49 per hour. For seasonal and small employers, and a small employer is defined as an employer with fewer than 6 employees, the current rate is $14.53 per hour. For agricultural employers, the rate is $13.40 per hour. The cash wage for tipped workers is currently $5.62 per hour, and the wage for long-term care facility direct care staff members is currently $18.49 per hour. And we'll go through some of these categories in more detail in the next few slides. The minimum wage for small employers. To be defined as a small employer under New Jersey's minimum wage law, you must meet both of the following 2 requirements. First, during the current calendar year, you had fewer than 6 employees for every working day during the majority of the work weeks, and during the previous calendar year, you had fewer than 6 employees for every working day during at least 48 calendar work weeks. And if you're a business that's newly established during the current calendar year, you would be considered a small employer if you employed less than 6 employees for every working day during a majority of the calendar work weeks in the current calendar year. Effective on January 1st, 2025, the state minimum hourly wage for small employers is $14.53 per hour. And the key thing to remember for small employers is that to be defined as a small employer, a business has to have less than 6 employees. So if you have 5 or fewer employees, you could be considered a small employer. But if you have 6 or more employees, you would not be considered a small employer under New Jersey's minimum wage law. The minimum wage for seasonal employers. And to be defined as a seasonal employer under New Jersey's minimum wage law, you can meet one of these 3 options listed below. The first option is that your business provides services only in a 10-week period during June, July, August, and September. Option number 2 is that during the previous calendar year, at least 2/3 of gross receipts were received in a continuous 16-week period. Or the third option is during the previous calendar year, at least 75% of wages paid were for work performed during a single calendar quarter. Now, seasonal employers do not include labor on a farm, and the 2025 minimum wage rate for a seasonal employer in New Jersey is $14.53 per hour. The minimum wage for tipped workers. The combination of wages and tips must equal at least the minimum wage per hour. If the tips plus the hourly wage are less than the minimum wage per hour, then the employer must make up the difference. Effective January 1st, 2025, the cash wage for tipped workers is $5.62 per hour, with employers able to claim a $9.87 tip credit. If an employer fails to pay the minimum cash wage to their tipped worker, which is $5.62 per hour, they cannot use a tip credit for that worker and would then need to pay them the full minimum wage, which is $15.49 per hour in 2025. And you can learn more at our website here. A tipped employee is any worker, full-time, part-time, or temporary, engaged in an occupation in which they customarily and regularly receive more than $30 per month in tips. Under New Jersey's wage and hour law, an employer is eligible to apply a tip credit against the full state minimum hourly wage only if the employer has informed its tipped employees in advance of the following pieces of information: the amount of the cash wage that is to be paid to the tipped employee, the amount of the tip credit which will be claimed by the employer, which may not exceed the value of the tips that were actually received by the employee, that all tips received by the tipped employee must be retained by the employee except in the case of a valid tip pool arrangement limited to tipped employees, and that the tip credit shall not apply to any employee who has not been informed of these requirements in advance by their employer. When an employer takes a tip credit, overtime is calculated on the full minimum hourly wage, not the lower cash wage payment. Record-keeping requirements. Employers must keep records that include the name of the employee, their address, the rate of pay, the gross and net wages, itemized deductions, the mode of payment, the check date or pay date, and earned sick leave. Employers must keep records. Employers need to keep daily and weekly records of the exact hours their employees work each day and within a week. Time records must be true and accurate to the work performed by an employee. For minors, employers must also document the arrival and departure times, in and out times for their meal periods, and the schedule of hours and breaks for minors must be posted. Wage payment law and paycheck deductions. An employer must notify employees of their rate of pay and their regular payday upon hiring. They must also notify them of any changes in rates of pay or paydays prior to those changes taking effect. They need to provide employees with a statement of deductions for each pay period, and also pay wages on regular pay days. Employers cannot withhold wages or make illegal deductions. Each time an employer pays wages, they must provide a statement of deductions to their employees. They must list the gross and net wages and all individually itemized deductions, such as taxes. This statement can be provided to the employee either electronically or in hard copy. And a few examples of illegal deductions. This could include shortages or breakage, damaged company equipment, failure to return company property, drug or pre-employment testing, except in some cases for security guards, uniforms or uniform maintenance in most cases, payment for a license, certification, or a certificate that's required to do the job. Overtime requirements. Overtime pay for an hourly employee must be 1.5 times the employee's regular rate of pay for every hour that they work over 40 hours per week. Employers can require their employees to work overtime. However, in that case, then the employer must pay the appropriate overtime rate. The employer and the employee cannot together agree to violate the state overtime laws. So when the employee works more than 40 hours a week, starting with that 41st hour, they must be paid the proper overtime rate. Exemptions from the overtime law. There are two types of salaried employees, exempt and non-exempt. In order to be considered exempt from overtime, an employee must meet the individual criteria for the specific exemption claimed. Examples of this are the executive, professional, administrative, and outside sales, skilled mechanics, limousine drivers, certain trucking industry employees, labor on a farm engaged in agricultural work, computer professionals, etc. And all of these exemptions are defined in the federal Fair Labor Standards Act. So you have to make sure you're meeting the requirements for these specific exemptions if exempting an employee from overtime. And it should be noted that exemptions should be claimed and granted provided that they meet those requirements under the Federal Fair Labor Standards Act. Child labor. What does the Division of Wage and Hour Compliance do? We investigate and inspect workplaces. We review and verify hazardous jobs for the minor working papers process, and we provide education through child labor law presentations. Minors under 16 years old are not allowed to work more than 40 hours per week and 8 hours per day, with certain exceptions for agricultural work. Employers are required to register online with NJDOL before hiring a minor, and an employer would go to myworkingpapers.nj.gov in order to get started. Job opportunities for minors. At 11 years old, they can work in newspaper delivery. At 12 years old, they can work in agriculture, and on our website you can find more information about minors working in agriculture. At 14 years old, they can work in general employment, but with some restrictions on hours and industries. And at 16 years old, they can work in general employment, but with more hours and more choices of industries and different types of work. Theatrical work is available at any age, and all minors who are working and being paid in New Jersey have to apply for working papers at myworkingpapers.nj.gov. Now we'll talk about job opportunities for youth at least 14 years old. This could include salespersons, including telemarketing, clerical and office jobs, hotel jobs, restaurant jobs, retail store jobs, supermarket and food store jobs, amusement industry jobs, hospital and health agency jobs, and science and research industry jobs. Work that minors can't do. Until 16 years old, use power tools, do factory work, work at places serving alcohol. Until 18 years old, use deli slicers, trash compactors, or poisonous chemicals, work at construction sites, be affiliated with adult entertainment. And these are just a few examples. You can find more examples at our website of work that is off limits to minors. We want to note that the work accident rate incidence is twice the average for workers under the age of 18. So it's really important that young workers stay safe and work in jobs that aren't dangerous for them. And for more information, please visit our website that's listed here. Hours of work for all minors. They may not work more than 6 consecutive days. 6 consecutive days does not need to be within one work week. So for example, a restaurant has a work week of Monday through Sunday. The minor works Thursday, Friday, Saturday, and Sunday of week 1. Then on week 2, she works Monday, Tuesday, and Wednesday. Within any given work week, she's only worked 3 to 4 days per week. But from Thursday to Wednesday, she's worked 7 consecutive days, which is more than this requirement of the law, and that would be a violation. Minors may not work for more than 6 continuous hours without an interval of at least 30 minutes for a meal period. And during these meal periods, a minor can't be constrained, and they have to be allowed to leave the premises if they choose to do so. All meal periods must be documented by the employer, and minors under 16 years old may not be employed during school hours. These minors can work outside of school hours or during vacations. Hours of work for 14 and 15-year-olds. During school weeks, they can work no more than 18 hours per week, no more than 3 hours per day on school days, and no more than 8 hours per day on Saturday or Sunday. They can work from 7 a.m. to 7 p.m. with limited exceptions. During the summer, which means the last day of school until Labor Day, they may work up to 40 hours per week and up to 8 hours per day from 7 a.m. to 9 p.m. Hours of work for 16 or 17-year-olds. During school weeks, they can work no more than 40 hours per week, 8 hours per day. They can work from 6 a.m. to 11 p.m. on weekdays, 6 a.m. to midnight on Fridays and Saturdays, or days that are not followed by a school day. During the summer, from the last day of school until Labor Day, they can work up to 50 hours per week and up to 10 hours per day. Overtime and child labor. The general rule is that overtime pay for an hourly employee must be 1.5 times the employee's regular rate of pay for every hour worked over 40 hours per week. Now, overtime only applies in very limited circumstances for minors. So as we said before, most minors under 16 years old cannot work more than 40 hours per week. However, minors that are 16 or 17 years old are eligible for overtime pay during the summer in the following industries in which minors are also entitled to the minimum wage. And this includes retail mercantile, food service and restaurants, hotel motel, beauty culture, laundry cleaning dyeing, light manufacturing apparel, and the first processing of farm products. In any other job, these workers who are 16 or 17 years old can work up to 50 hours per week during the summer only, but they're exempt from overtime pay. Misclassification. Misclassification is the practice of not properly classifying a worker as an employee. This can take the form of identifying the worker as an independent contractor or simply not identifying the worker as either an employee or independent contractor by paying the worker off the books. What is misclassification? Misclassification is illegal and can occur when employers force their workers to form an LLC or sign an independent contractor agreement, or when employers issue a Form 1099 as opposed to a W-2 form. New Jersey uses what is called the ABC test to determine whether a worker is properly classified. Misclassification deprives workers of many rights that are guaranteed to employees. When an employee is paid cash off the books, that also means that the employer is not giving them access to the usual employment-based protections, such as access to Social Security insurance, unemployment insurance, temporary disability leave, and family insurances. Who is classified as an employee? And this is the ABC test. If a worker performs a service and is paid, they are presumed to be an employee, unless the employer can prove all three of the following requirements. A, that the individual has been and will continue to be free from the employer's control or direction. B, that the work is outside the usual course of business for which service is performed. And C, that the individual is engaged in an independently established trade, occupation, or profession, and the employer must prove all three of these following requirements for an employee to be classified as an independent contractor. These are some signs that an employee may be misclassified as an independent contractor. A few of these signs are that the employer directs and controls the worker's work, they provide training, tools, or supplies to do their job, they specify the worker's responsibilities, or if the employee's work is similar or the same to the work that's done by the business where they're working, and also if that worker only works for one employer. These are just a few examples that may indicate that a worker is not truly independent to meet the independent contractor classification under the ABC test in New Jersey. Workers are protected against misclassification under New Jersey law. If a worker is misclassified, they are not in trouble, the employer is. Under New Jersey law, if an employee is misclassified, then they are entitled to the following remedies: back pay for payments that are due under New Jersey's wage and hour laws, entitlement to rights that are guaranteed to employees, which include workers' compensation, unemployment benefits, temporary disability insurance and family leave insurance, earned sick leave, and job-protected leave. Workers can be awarded up to 5% of their gross earnings over the past 12 months as a penalty for the illegal practice of misclassification, and they could also be eligible for reinstatement or correction of discriminatory actions taken in retaliation against an employee making an inquiry or complaint about possible misclassification. Employer obligations under the New Jersey Workers' Compensation Law. Employers are required to carry the appropriate workers' compensation insurance. If an employee is injured, they will receive benefits regardless of who is at fault. In exchange for these benefits, the employee cannot bring a civil action against their employer for pain and suffering or other damages, except in cases of intentional acts. Worker compensation insurance also provides death benefits to dependents of workers who have died as a result of their employment. Employers cannot discriminate against workers for claiming workers' compensation benefits, and you can learn more at our website, which is listed here. A wage and hour complaint. Employees can file a complaint in case of improper record keeping, failure to pay minimum wage and overtime, illegal deductions, failure to provide payment for earned sick leave, retaliation, threats or actual acts of retaliation, misclassification, child labor violations. These are just a few examples of possible violations of New Jersey's wage and hour laws that could lead to a complaint. What is retaliation? Retaliation occurs when an employer penalizes an employee for asserting certain workplace-related rights, such as the right to be paid the minimum wage or paid sick time. Retaliation can take many forms, including but not limited to getting fired, receiving a poor performance review, changed salary, increased oversight on job duties, changed workplace responsibilities, or being denied a raise or a promotion. Workers have a right to learn about their rights, to question how those rights are applied to them, to report violations of those rights, and to demand those rights without interference from their employer in asserting those rights. And workers can assert their rights by privately speaking with human resources about how they're being treated, sharing concerns about their workplace with a coworker, filing a complaint in court against an employer, and these above actions are protected activities under both state and federal law. New Jersey has very strong laws against retaliation, and workers are protected from being retaliated against if they have a wage and hour concern. Thank you for watching our presentation today, and if you have any further questions, you can reach out to the New Jersey Department of Labor and Workforce Development, Division of Wage and Hour Compliance, at our contact information that's listed here on this slide. We're happy to help answer any questions you might have, clarify any confusion or knowledge gaps with the laws, and we thank you for your interest in attending our webinar and your efforts to create good jobs and support workers in New Jersey.